Good afternoon. I'm Yohnka. You've already seen me this afternoon, and I want to welcome you into this little bit of a bonus session and talking about police reform. A couple of pieces of housekeeping as we start. You'll see that we have live captioning for this event this afternoon. And so you'll be able to view that. You can just click the closed caption button on your screen, and you'll be able to see those captions. The other thing I want to mention is we're going to have some time in this program to take your questions. You can use the Q&A function in order to do that, and the questions will then be fed to us, and we'll be able to talk. Our topic today is the future of policing and police reform and police accountability in particular. As all of you know, in the wake of the murder of George Floyd, we saw a mass movement across this country insisting on additional accountability for police and about the system of policing in the United States. And there has been, I think, as predictably as one might imagine, some pushback to those efforts. And also, we're all experiencing the difficulty of creating change in the policing area. And so that's really what we're going to discuss over the next about 26 minutes. I am really pleased to be joined by two people who know way more about this than I will ever know. The first is Aziz, law professor at the University of Chicago, who you saw in the session with David Cole during the main lunch. And the other is the deputy legal director for the ACLU of Illinois, my colleague, Michelle Garcia. So Aziz and Michelle, first of all, welcome and thank you for joining us today.
Thank you for having us.
Thanks for having this important conversation, Ed.
So Aziz, I want to start in your book, which I'm going to hold up here, on the collapse of constitutional remedies. You spend a fairly good amount of time talking about a particular challenge to police reform and police accountability known as qualified immunity. I wonder if you could just talk a little bit about qualified immunity, what it is and why it presents such a challenge to getting more accountability in a policing system.
So, Ed, I'm going to first complain that you didn't hold my book up for long enough, but
sorry,
that can be remedied. So long as your arm can hold it. There we go. Qualified immunity is a judge-made rule that limits the availability of damages when a state official violates someone's constitutional rights. The reason that the rule of qualified immunity is important is that starting in the 1950s, at a moment at which many American jurisdictions had policing that was overtly racist, that was brutal above and beyond what we see today, both lawyers and community movements looked to the federal courts as an instrument to rein in the police. This was particularly true in the American South. And the courts used the Constitution as a tool for doing that. In particular, they used the idea of giving damages to people who were victims of police violence in the expectation that that wasn't just the correct and fair remedy for the victim, but it provided a disincentive for police officers to commit like unconstitutional acts in the future. And because that was a relatively successful move early on in the 1950s, it's become one of the dominant instruments for regulating the police. It's not the only one, but it's an important one. Conservative judges, starting in the 1970s, developed the idea of qualified immunity. There's no federal statute, there's nothing in the Constitution that licenses it. Essentially as a gatekeeping rule to limit the number of constitutional cases And by today, it has become the exception that swallowed the rule. And it means that the traditional method of holding police accountable in federal court for constitutional wrongs they commit is essentially useless.
So it's a court-created remedy, which means that a legislature, could do away with it. And in fact, we've had a bill here in Illinois designed to do just that. But we run into this problem because police fiercely protect this. They make all kinds of claims about what it will do to policing, or, people will leave the profession, or police officers will lose their homes. What do you say to those arguments about this undoing of this, as you say, court-created kind of block?
I think there's a couple of things to say to those who oppose reforms that would generate accountability, whether it's in the form of tort damages or something else, with respect to policing. The first thing to say is there is absolutely no reason to think, and indeed there's quite many reasons to think the opposite, that we are at some kind of ideal or optimal point in terms of police behavior. We know that there is an enormous amount of police behavior that is unlawful or unconstitutional. We know that the number of instances in which people even bring a complaint is astronomically smaller than the number of instances in which there's actual unlawful or unconstitutional behavior. So to imagine that that qualified immunity strikes the right balance, right? Even if you were interested in, not particularly interested in civil liberties, is absurd. The second thing to say is that I think many of the arguments, particularly against damages remedy in the policing context, rest upon a lie or a myth. And this is the myth that police officers pay damages awards from their own pockets. This is something that the Supreme Court has said a number of times, and it's just not true. It's just not true. Every jurisdiction in the country, large or small, either has its own insurance policy or it pools together with a number of other neighboring jurisdictions to buy an insurance policy that collectively covers several bodies. And these insurance policies cover damages awards in cases of police brutality. Indeed, even when an insurance policy contains an exception saying that an officer who commits an unconstitutional act will not have a damages award covered if they're criminally prosecuted, even in those cases, what we see in the world is insurance companies covering those claims. So the notion that the officer here is the little guy who has something to fear because of the imposition of crushing liability is wildly out of touch with reality.
So, Michelle, qualified immunity is one block to the process of getting accountability. There are other mechanisms towards doing that, one of which we're seeing here in Chicago and that you're involved in is through a federal court overseeing consent decree. I wonder if you could talk about how that works and how that helps to bring about accountability for police here in the city of Chicago.
Sure. So right now there's a federal consent decree called Illinois versus Chicago. And it is a lawsuit that was brought by the Illinois Attorney General's office against the city of Chicago after the U.S. Department of Justice did a 2-year study of the police department and found that they were committing a pattern and a practice of unlawful and excessive use of force, primarily against people of color, Latinos and African Americans in the city. And when former Attorney General Sessions decided that the federal Department of Justice wouldn't file suit, the Illinois Attorney General's office stepped in. Now, after they stepped in, the ACLU also filed its own lawsuit as well. And known as, on behalf of several different community organizations and civil rights organizations, because we wanted to make sure that the city was, we wanted to make sure that the city was aware and that the community was aware and that the federal courts were aware that this, not only was the city engaging in abusive, unconstitutional practices against people of color, but also people with disabilities. And our community partners, the Campbell also filed a lawsuit as well against the city. Now, we ended up settling our lawsuits to be a part of this federal consent decree, where we can file motions to enforce the consent decree and be involved with negotiating 10 different kinds of policies related to the CPD's policing. And what I mean by that is that we're there negotiating and providing comments from the community to the Attorney General, to the police department, to the independent monitor, and to the judge about how these critical things must change to bring apart reform.
So let's get into this just a second. When we start talking about reform and change, and we talk about all of these policies, what underlying it, I guess I'm asking, sort of what is the vision of what the community partners you work with want? What is it they'd like to see in terms of policing in these communities? What is it they hope for?
Well, with our coalition partners and our clients, the different civil rights organizations that we work with and the organizing community, what we're hearing from them is this. Chicago's had a long history of abusing and discriminatory and unconstitutional policing, from engaging in stop and frisk of people on the street without cause, to excessive use of force, to wrongful raids of people's homes. And this has disproportionately impacted people of color. So what we're learning from our community partners and our coalition partners in this case, what they want first is for CPD to change their policies so that they're following the law, and that there be adequate training, so there's understanding, and third, that there be accountability, so that when officers violate the law, when officers, for example, wrongfully raid someone's home, or stop someone on the street, or shoot someone, that there's an ability to remove them from the force. And that's what we're hearing from our community partners. It's not difficult, but because we're dealing with a lot of systemic, deeply ingrained racism and frankly, just terrible practices, it takes a while to reform that.
So, Aziz, if I can come back to you, I wonder how you see this question of policies and accountability. Do those have to be linked together to make police reform meaningful in a real way for people?
I do think that they're related. And I understand that people's eyes glaze over when they hear the word policy. But here's how I would pitch to you the connection and the importance. The problem of police violence is a little like the problem of climate change. We all know that climate change is a catastrophic problem that has enormous complexity, and that only occasionally flashes into public attention when there are massive fires in California, or there's flooding in Florida, or what have you. And the problem of getting movement on something like climate change is the problem of translating very, very short periods of public attention into sustained action that targets the many and complex threads that go into our climate crisis. police accountability and the problem of police violence and brutality is a lot like that. For the reasons that Michelle, I think, really nicely just explained, the problem of unconstitutional policing bubbles up out of institutions that have developed over a long time that are really thick, hard to get a handle on bodies of practices, habits, traditions, cultures within a particular police station or what have you. And they're embedded in a larger environment of a city, which has its own political culture, which nobody ever has said is a healthy culture. And yeah, we have these moments like the release of the Laquan McDonald video, like the George Floyd murder, which public attention snaps onto this dramatic illustration of the problem. But public attention waxes and it wanes. And in particular, when confronted with other demands, right? Particularly when people start thinking about, well, what if I'm going to get mugged? The fact that policing may not actually be doing a good job of providing security when it's needed, and that failure might be connected to those acts of unlawful brutality, all of that falls away and people forget. And so just as in the climate context, I think you ought to think about the problem of police accountability as a problem of staying power, a problem of attention, and a problem of keeping political will with think about it with keeping your foot on the gas with respect to reform, not just in the moment at which people are out on the streets, but for the weeks and the months and the years that follow. And I think that's a lot like the problems that I know many of us are concerned about in other spheres. But I hope that the comparison is something that helps you grasp why, in particular, the work that Ed and his colleagues do in the legislative sphere is so important.
So Aziz, one of the questions we got in the chat, let me just ask, going back to QI for just a moment. Somebody asked if lawsuits are really an effective tool for curbing police behavior, if in fact, as you point out, the officers are not actually on the hook for damages.
Yeah, I think that there's a healthy and actually not as tedious as you would imagine academic debate on this. And here's I think the bottom line. I do think that there's good reason for thinking that damages awards make a difference. And indeed, in almost every other area of human conduct, we think that damages awards make a difference. We think that tobacco companies change their behavior. We think that gun manufacturers change their behavior. We think that medical device manufacturers, which mess up what they've been doing, hip replacement part, change their behavior if they're subject to damages awards. We have actually pretty good evidence that municipalities respond to damages awards, in part because insurance companies really don't want to end up paying big settlements. And insurance companies actually impose a lot of pressure on police departments to adopt best practices, to reform their culture, to fix all the kind of problems that Michelle talked about. I think it's a slightly different problem in big cities. Big cities like Chicago tend to insure themselves. And so there's a political rather than a financial dynamic. And there, I think that damages awards are important, but they're important because they're markers and they're moments at which not just people on the progressive side, but even fiscal conservatives can get on board with respect to the need for reform. So I think that they play a different role in Chicago in comparison to smaller jurisdictions. But across the board, I think there's very good reason to think that the damages awards do play an important role.
So Michelle, I'm gonna come back to the politics I think that you raised there in a different way, Aziz, in a moment. But Michelle, I wonder if we could talk in specific when you look at reform the complexity and just the steps one has to go through just to improve something like foot chases in Chicago, which I think many people are familiar with here and concerned about as the result of a couple of recent cases with Adam Toledo and Anthony Alvarez. And I wonder if you could talk a little bit about how an issue like that gets played out within the consent decree.
Sure, absolutely. I think we all, last spring, we were faced with 2 foot pursuits and video of 2 foot pursuits that horrified and electrified the nation. We had an instance with Anthony Alvarez, both of them ending with officers shooting Anthony Alvarez and Anthony Toledo, who was a child of 13. When we're thinking about how that works in the context of the consent decree, as a result of those shootings, the CPD released sort of an immediate policy on purportedly how they were going to address when an officer could engage in a foot pursuit. And frankly, it's just a chase. When an officer can chase someone down. And it immediately came out shortly, less than a month after the horrible deaths of both Mr. Alvarez and the child. And it wasn't good enough. So in the context of the consent decree, the ACLU and our coalition partners and our community members gave extensive comments on how it needed to be improved. And then the police department took that into account to some extent, as well as the Attorney General and the monitor, who also provided input on the foot chase policy to make sure that it complies with the principles of the consent decree, which require constitutional policing and policing that does not result in excessive use of force. And I think that we would all agree in the situation of both those 2 people that passed away, that was an example of excessive force. They died and they didn't need to. So they released an interim policy in February. This policy in February, the ACLU, we went into action and worked with our clients who are community organizers and went through it and discussed it with our coalition partners. And we put forth public comments to show that this policy wasn't good enough, that it still allowed, mainly that it still allowed the CPD police department to chase someone even when they don't have probable cause, to chase someone even when an officer can't see the person that they're chasing. And when we're talking about chasing, we're talking about an officer running with a weapon. That is an inherently dangerous pursuit and really should be used at the last resort. So we provided 13 points of comments directly to CPD, and then working with our coalition partners and community members as well in the public portal. And these comments were due by February 25th. Now we are pushing that the CPD listen to the community, engage in community engagement on this policy, and revise it again. And that is how we're using the consent decree to change critical policies that have on the ground effects on average Chicagoans, Latinos, particularly Latinos and African Americans in Chicago.
So I don't want to put you on the spot, Michelle, but literally as we have been here, I just got an alert that the consent decree has been extended by 3 years. That the judge in the case agreed to that. I think during a hearing you knew was happening right now. I wonder, is that just a demonstration of how difficult and how hard this work is, that it's going to take a long time to change these policies and then change the way they're actually effectuated on the streets?
I think so, but I think the way I see it is not one of despair, right? But one of commitment. Here we have the Attorney General and the judge and even the police department recognizing that there is a lot more work to do, and there's a lot more work that can happen. And it's not one where they're throwing up their hands and saying that you've met the minimal basis. My impression, that is the judge who's saying, look, there's a lot more to do, and we haven't finished. And in some cases, CPD has failed. And when you've looked at the CPD's own Inspector General report and the data reflecting that these unconstitutional and policing encounters, particularly with people of color and with people with disabilities, are continuing, we've got to do more. And so I see that, and I did get that notice, I see that as a good thing. I see that as a long-term commitment, which frankly, if we are reforming decades and decades of abuse, it's not going to happen overnight. And as Aziz said, we need to keep our finger on the pulse. And what I say we, it's not just the attorneys of the ACLU, it is the people that are members of the ACLU, it's the people that donate, it is the people that value human life and value the diversity of our beautiful city of Chicago.
So we are almost up against this, but Aziz, I want to give you a chance on something which I think is probably on people's minds. And that is we're hearing this kind of public debate that somehow we can't fight violence and do reform of the police at the same time. Do you think those two things are inconsistent and we shouldn't think about doing them at the same time, enhancing public safety and demanding more police accountability?
No, I think it's a myth that's been propagated across the last 70 years that the problem of American violence is the problem of not having enough coercive state action. I think if you look at the development in the history of our criminal justice institutions and the way in which we decide whether or not to extend a helping hand or the government decides whether or not to extend a helping hand to those who need it. What one sees is that on the criminal justice side, there have long been both problems of under-enforcement and over-enforcement, that the state fails to protect at the same time that it engages in excessive and unlawful and unconstitutional coercion. And it's really key to see that both of those things coexist. And one of the really important pieces of the work of the ACLU of Illinois has been in challenging the way that our policies, or the city's policies, fail to protect particularly Black and Hispanic communities, even as they impose particularly young men and boys in those communities to horrific levels of risk of police violence. And it is only by grappling with the complexity of that situation, the situation of under and over enforcement, and only by seeing the ways in which lawful policing addresses, under the rule of law, under our Constitution, addresses both the under and the over enforcement problems, and is part of a much wider rethinking of the social contract that I think many of us would strive toward, in which every single community in our state can look forward to calling the police and having them arrive in a timely way when they're at risk from let's say, domestic violence or one of their neighbors. But at the same time, nobody across the state needs to worry about being stopped in their vehicle, stopped on the sidewalk because of the color of their skin, and treated in ways that are at best disrespectful and at worst violent and harmful by the officer in question. So no, I don't think there's any contradiction between those at all.
So as always happens, we are literally just getting started in this conversation and the time is over. So I want to first thank Aziz and Michelle for joining us this afternoon. I want to thank all of you for being here. I promise you this is not the last you're going to hear from us about police accountability and police reform. So stay tuned, follow our emails, follow our social media, we may even have something to say about this latest development before the afternoon is over. So thank you all very much for joining us, and have a great afternoon.
Thank you, Ed. It was a lot of fun.
Thanks.
Thank you.